Welcome to Learn Short and Typing with VIKAS Sir. Legal matter and general matter for Chandigarh High Court and allied courts. Exercise number 21 at the rate 100 word per minute. Be ready, start. This new change has to come if the judicial system is to become an effective instrument of social justice, for without it cannot survive for long. Fortunately, this change is gradually taking place and public interest litigation is playing a large part in bringing about this change. It is through public interest litigation that the problems of the poor are now coming to the forefront, and the entire theatre of the law is changing. It holds out great possibilities for the future. This writ petition is one such instance of public interest litigation. It is true that construction industry does not find a place on the schedule to the Employment of Children Act 1938 and the prohibition enacted in Section 3, subsection 3 of the Act against the employment of a child who has not completed his 14 year cannot apply to employment in construction industry. But apart altogether from the requirement of Convention number 59 of C, the International Labour Organization, and ratified by India, Article 74 of the Constitution provides that no child below the age of 14 shall be employed to work in any factory or mine or engaged in any other hazardous employment. This is a constitutional prohibition which, even if not followed up by appropriate legislation, must operate, and construction work being plainly hazardous employment, it is clear that by reason of this constitutional prohibition, no child below the age of 14 years can be allowed to be engaged in construction work. Therefore, notwithstanding the absence of specification of construction industry in the schedule to the Employment of Children Act 1938, no child below the age of 14 years can be employed in construction work, and the Union of India, as also every state government, must ensure that this constitutional mandate is not violated in any part of the country. Magistrates and judges in the country must view violations of labor laws with strictness, and whenever any violations of labor laws are established before them, they should punish the errant employers by imposing adequate punishment. The labor laws are enacted for improving the conditions of workers, and the employers cannot be allowed to buy off immunity against violations of labor laws by paying a paltry fine which they would not mind paying, because by violating the labor laws they would be making profit which would far exceed the amount of the fine. Full stop.